Hello and welcome to Legally Speaking with me, Tarun Nagia. A bench of justices, Justice G.S. Patel and Justice Madhav Jamdar, have authored a judgment with far-reaching consequences for the business community and something that will be praised in industry circles, banking circles, business circles, investors in India by all. Indeed, a laudable judgment where they have said that banks don't have authority to issue lookout circulars, and they were hearing a clutch of petitions in this regard, where businessmen were stopped from going abroad, which prevented them from undertaking their regular business activity. It is not a small thing when a businessman is stopped from going abroad, but what are the implications on business, banking, opportunity cost, employment? My panel will be able to tell you better. Let me welcome Advocate Vaibhav Gaggar. He's an arguing counsel at the Delhi High Court and the Supreme Court. Good to see you, Vaibhav. And looking for some interesting insights from you. I have with me Advocate Karthik Seth from Chambers of Karthik Seth. Good to see you, Mr. Seth. And looking forward to some interesting insights on this issue from you as well. At the outset, let me request Vaibhav that you can you share us some anecdotes and some issues from what this judgment has led to before we move on to the discussion. Over to you, Vaibhav.
Thanks, Tarun. Always a pleasure to be on your show. As you rightly pointed out, I think it's a massive judgment, and the industry is receiving it very, very positively for straightforward reasons, right? It had almost become like an axe, hanging over everyone's neck, because every time there's an NPA, and till last year, there were 36,000 cases filed for NPAs, 36,000. If in 6 months, the NPA did not get resolved, it would become a willful defaulter, in which case the banks would start issuing LOCs. Now, if that trend had continued any further, I don't think there could have been a greater damage, right, to the industry sentiment, to the investor sentiment. So immediately upon that happening, I can tell you that through the day I've been receiving calls, trying to get into the intricacies of this, because there are a number of people who have suffered at the hands of this particular circular. The judgment is not out yet, so we don't know the finer details of this, but it's obviously going to be quite nuanced. And this is a step further, Tarun, because if you'd recall, Justice Subramanian Prasad in Delhi High Court had also rendered 2 judgments last year, which had kind of dealt with the issue, not held it unconstitutional, but dealt with the issue of these LOCs and said it's only in exceptional circumstances it can be done. There is a route that's got to be followed. And again, for obvious reasons, because an LOC is a coercive measure. You are being treated as a criminal for a civil default, right? What that does to any businessman is for anyone to guess over here. There may be exceptions where people may have defalcated funds and are trying to run away from the system. But that's really an exception to every rule. Are we, the presumption in bringing about this LOC circular was that everyone who's defaulting is going to be a criminal. Now, that having been removed today, I think is going to be a very positive sentiment. And you never know. Let's see what the stock market reacts like tomorrow. I'm hoping for a good one.
But thanks for the opening comment, Vaibhav. I'll go to Karthik Seth. Karthik, could you discuss the implications of this judgment authored by Justice G.S. Patel and Justice Madhav Jamdar?
Thanks, Tarun, for having me again. So basically, first things first, as you might be aware, Justice G.S. Patel actually retired yesterday. That was his last day in office. And this judgment was actually reserved for a year. So it was bound to come out yesterday. And the reason why I say this is because coincidentally I was in Bombay and there was a lot of noise about this judgment coming out and all those things.
Yes.
But people might have missed out another judgment which was passed in February of this year, which was exactly on the same lines by the Karnataka High Court by just a single judge headed by Justice Krishna Dikshit. Exactly the same judgment was passed at that time as well. And in that case, the only thing which was considered is that this is the 2018 circular issued by the government. Now, I am not setting aside the judgment, setting aside the circular. But the powers of the public sector banks to issue lookout circulars was set aside in that case as well. And this particular judgment was also at that time very widely circulated. I am pretty sure when the judgment will come out, that will definitely include the judgment of 11th February 2024. Justice Krishna Dixit relied on various judgments of the Honorable Supreme Court and specifically quashed each and every public sector banks lookout circulars issued for the state of Karnataka at that time as well. So just on one is that particular point. The other is where Justice Gautam Patel and Justice Madhav Jamdar in their judgment have specifically said that this judgment is definitely welcome. It is good for the market. It's good for the industry. But at the same time, this will not have any bearing on any order issued by any courts of law or any tribunal. So if there is a lookout circular or anything issued by them, this judgment will not have an effect or bearing on that, even though, because what has happened is...
Karthik, I want to hold you before you move ahead, before I go to Vaibhav.
Yeah.
You are saying what has already been issued, this is not retrospective, that proceedings goes on. This is all for... Can you explain?
No. I'm not saying this is not retro. Anything which is issued by a public sector bank, that gets quashed for sure. But for example, if there is a particular bank which issues, a court or a tribunal, for example, NCLT or NCLAT or any other tribunal issues a lookout circular for a particular person who has been declared an NPA or anything, as Mr. Gaggar was pointing out, in those cases, this will not come into effect at all. Even though banks would be involved in those cases as well. But because it is only about the power of a public sector bank to issue a lookout circular. This is what my interpretation is.
Okay, point well taken. The petitions had said that the circular curtails fundamental rights, the fundamental right under Article 21. They also said the economic interests of India cannot be equated financial interests of any bank. And the financial interests of a particular bank are not to be compared with the financial interests of India. Wherever you deal with a lot of such commercial cases, you understand what happens when a businessman mobility is curtailed. I am not alien to the fact that you land up at the airport. One bank says that, you cannot travel abroad. So you go to that bank, you get it set aside. You go to the airport, then the second bank, sometimes 5 banks have issued lookout circulars. Do you think that this has resulted in a lot of harassment for our businessmen in the past 3-4 years? And this is a welcome change and better late than never.
Absolutely, Tarun. No two ways about it in my head. With greatest respect for whoever may have an opposite opinion on this. The fact of the matter is that business requires the flexibility for the promoters to be able to travel, to be able to go about the daily business, to be able to go out and actually expand their business. They need to raise finances. They need to do their strategic meetings, etc. Now, please assume for a moment that this LOC had remained. As I said, almost 36,000 NPAs already, right? You're talking about some of the finest companies otherwise, who may have had a blip in their business. Effectively, therefore, what you were doing was you were taking away the opportunity or the chance for that business to revive. Now, if that is not injurious to not just that business, but the economy as a whole for the nation, then I don't know what else would be. And this is not even getting into the individual rights of the individual, of the person concerned. I'm saying purely economically for the businesses and the national economy, this was a bad order, a bad LOC, bad circular. Now coming to individual rights, you have been, if an LOC is issued, what is an LOC normally issued for? That you're escaping investigation. You're escaping the process of court. You're trying to run away. You're trying to defraud the system. That is when an investigative agency empowered under the CRPC or through this is mandated to come out with an LOC, which also then bears judicial scrutiny. Please understand, there is, in this particular system, you had a bureaucrat or you had somebody in a national bank, nationalized bank, getting up and saying, that's an NPA, now willful defaulter, LOC to be issued. Without any scrutiny, without any inquiry, without any investigation, and without really having the power under the CRPC whatsoever to restrict your right to mobility, to travel. That would have been, I mean, that's absurd. I'm surprised it's taken that long, quite honestly. And I'm pretty sure the judgment is going to get challenged as well. But the fact of the matter is that for an individual, ever since 1978 onwards, you know, if you recall the Maneka Gandhi judgment as well, the rights are enshrined, right? You cannot just take away that right without due process of law. What is the due process of law in envisaged in this circular? Some bureaucrat or some banker sitting there and saying, oh, you could be fleeing the country. And that's it. I mean, the kind of absurdity that was leading to was horrifying, Tarun. And it is welcome. It's most important that, you know, the system continues to promote the businesses, to back up the promoters who may have been having a tough time. What did COVID do to a lot of businesses? Are we saying anybody who went into NPA and COVID should not be given an opportunity to even go ahead and raise their business again? Why? Because you've done a civil default. How can for a civil default you be put behind? I mean, you be issued an LOC. If an FIR is registered, investigation is happening, you're not cooperating, you're trying to flee, yes, LOC proceedings could be initiated. As my friend Karthik also mentioned over here, if it is a judicial body that has issued it, there is an application of mind. There are criteria to be met. You can't, it's a quasi-judicial or a judicial activity. You cannot have individuals sitting as bankers do this. And I'm glad that this judgment is come.
Thank you for that input. But the worry is, as you said, that this may get challenged. I'll go to Advocate Karthik Seth. Karthik, one thing I remember is Rajiv Bajaj from Bajaj Auto saying that during COVID, the government of certain European countries paid the salaries of private businesses to help them tide over the crisis. And he said in India, it was exactly the reverse. If we couldn't pay our bank loans, we went under NPA, we lost our companies to the insolvency code. So there is a certain attitude in Western countries to handhold the businesses when they are in trouble. And handhold is a word used in a very careful way, because in the end, if the government doesn't come to the aid of private businesses, they get collapsed and some foreign companies come and do the same business in our country. We lose market share, they take away the profits. It's simple economics. Given that background in mind, and we coming out of a difficult COVID, while we welcome this judgment, what ahead lies in store? Taking on from what Vaibhav said, could you just share the implications if this were to get challenged? Do you think it will get stayed and then banks get the right back till the adjudication happens in the Supreme Court? What are the possible things that can happen now?
Yeah, Tarun, very pertinent question. See, undoubtedly, as Mr. Kaggada also pointed out, it is going to be challenged. And Union of India is bound to challenge it and it will come up to the Supreme Court. In my opinion, as per the Supreme Court roster, it will go before the Honorable Chief Justice who's there right now. So I had just checked up before we spoke. So if it goes to, him, looking at the kind of judgment which will probably be pronounced, which has been published as of now, the quashing is only of the lookout circulars per se. It is not with regard to the office memorandum which was issued in 2018, which was under challenge. So you may kindly see, if you want to add there, you may add right now so that I'm clear on my particular point. So I genuinely feel that with regard to the office memorandum per se, it had other clauses as well. And one of them included that a public sector bank is also given the power to issue lookout circulars.
Okay, so the OM has not been stayed. Only this aspect has been stayed.
Only this aspect is what has been done. So that where I feel that the superior court, in this case the Supreme Court, would be reluctant to stay probably, because this is only with regard to the power of the public sector banks per se. Lookout circulars have been something which have been in existence in 1979 in India. For the first time, an office memorandum came for a lookout circular was in 1979. Later on, it was changed in 2000, where the Ministry of Home Affairs issued another guidelines with regard to lookout circulars. Then later on in 2010, again another one came. When in 2010 it came, it defined what is a lookout circular for the first time. So the reason why I'm mentioning this is because the major and the radical change which happened eventually in 2021 was, earlier under the 2010 definition, a lookout circular would remain only valid for 1 year. And until unless it gets renewed by the request of the authority which had for the first instance asked for the lookout circular, it will automatically lapse or expire. In 2021, the office memorandum specifically said that until and unless specifically requested for cancellation of this lookout circular, it will continue and there is no need for any renewal whatsoever. Obviously, these lookout circulars do not cover the lookout circulars or any bar on traveling issued by courts of law. This only talks about specifically for example, in this case, which is a public sector bank. So I'll come to a personal thing which is one of my clients has been dealing with without naming anyone. Leave aside the public sector banks. The private sector banks itself now are in a position which is very peculiar at this point of time. Today only we read that Kotak Mahindra has been asked to stop with regard to issuing credit cards and online and app-based services and all that. I mean, see, we need to see the situations which banks are in as well. They are, so for example, I'll not deviate too much. I'll just specifically say one of the biggest private sector banks in the country is going behind persons of good reputation and good repute and pushing them outside the country only because of some vindictive purposes, because they feel threatened that they will be pulled up by the government. So what I want to point out here is that thankfully courts are interfering and courts are making it look to the outside world that we are more economically friendly. You can come here and invest. You can stay here in India. And definitely, if the government, some way or the other, tries to curtail your economic freedom, we will put our foot down and help you out.
Point very well taken. I'll take this by extension to Advocate Vaibhav Ghakar. Vaibhav, I think banks are free to go to court and get an LOC issued. It's just that banks cannot issue it themselves. Do you think this circuitous route means the same thing, or things will be a lot more different till this gets challenged and stayed in Supreme Court? Secondly, please help us understand, the businessmen understand, what are the chances of such a thing getting stayed?
So, I tend to agree with Karthik, even though it's at anyone's peril to predict what would happen in courts. But having said that, just without the benefit of the judgment as well, right? On first principles as a lawyer, when I looked at this office memorandum and all, I found this condition to be unconstitutional for various reasons. As I said, an LOC is meant to be in exceptional circumstances after judicial scrutiny or quasi-judicial scrutiny for certain purposes only, right? It has been given to officers who are trained in that subject. When it is handed to a banker whose only motivation is to say that I need to recover my money, then this was being misused as a recovery tool. If something which is not envisaged for that purpose is being used, normally courts would intervene. And therefore, I would by implication imagine that it would not be very simple for the union probably to pull off a stay of this particular judgment. Number one. Number two, insofar as the rights of the individuals are concerned, while a court or a tribunal can issue an LOC, it is not done as a matter of course. I'll be very happy. I mean, I don't have the figures, but I can tell you in the last 20 years plus that I've been litigating, no, I've not seen courts issue in a civil commercial dispute, right, an LOC more than 2 to 3 times. It is an absolute exception to the rule that this is going to be done. If you're violating the orders of the court, you have committed to a court that you're going to be doing A, B, C, D, E, and you flee the country. Yes, I can imagine a court issuing an LOC, right? If you are involved in criminal activities, yes, an LOC is going to be issued. But until and unless, I'm sorry.
Is this an act of extreme measure?
Absolutely. Absolutely. And the courts are very clear about it, not just this judgment. As I pointed out, Justice Prasad's Delhi High Court judgment, he has very categorically held it is only in exceptional circumstances that an LOC can be issued. Even otherwise, by agencies, let alone bankers, right? So I can't, I mean, while theoretically, yes, the banks could, go to the courts and say, oh, please issue an LOC now. I don't see that happening as a matter of course at all. They would have to prove how is it an exceptional circumstance? What is their apprehension? Where is that apprehension of this gentleman fleeing coming from? That he's not traveling for a genuine business venture. The onus is going to be on the bank. And it's going to be very, very difficult for them to push for an LOC in every other matter the way they were doing right now. So I would personally not be very worried. As a businessman, I would take this as a very positive step. And I think the sentiment would remain positive going forward. Number one. Number two, also, we are in election mode. Never forget that. Union will file an appeal. Let's see what happens.
Point well taken. Union will file an appeal. Now we move on to a round of final comments given the paucity of time. We start with Karthik Seth. Karthik, can you comment on the message that this judgment has sent out to the industry, and what is the hope from the business community for the future on this issue?
So definitely this judgment needs to be welcomed in every sphere only because of one small reason, because as far as I have read the Karnataka High Court judgment, I don't think that the Bombay High Court judgment is going to be very far from that, where they talk about the Passports Act. There is a section 21 of the Passports Act, which clearly talks about how can this power be delegated to anyone else. And there it specifically says that this delegation can only happen to a government or a central government employee only. So in those, and only someone who is subordinate to the central government. Per se, whether a public sector undertaking is subordinate to the central government and all that, that's a separate question which we need to go into and all that at some point of time. In any case, prima facie, what Justice Gautam Patel has also done, this may be noted, he specifically said that office memorandums per se with regard to lookout circulars are not ultra virus to the constitution. So that is where, to that extent, he has protected the government. He's not saying you cannot issue an office memorandum with regard to lookout circulars, because they have been going on since 1979. That cannot be changed at this point of time. It is only with regard to a particular power being delegated to a person who is not central government per se. In my opinion, this is a very welcome move. And I mean, Mr. Gaggar also, we all have clients who have been facing problems with regard to the banks. But at the end of the day, as you rightly pointed out, what Mr. Bajaj had said during COVID times, if we are not going to help our own country's businessmen, who is going to help? Then you will have a plethora of non-resident Indians or OCIs who will eventually, after recovering from these back debts and everything by earning outside the country, and then you will award them with Pravasi Bharatiya Samman and all those things. This is precisely what has happened. And in Karnataka High Court judgment, this is precisely what has been noted down. One particular B.R. Shetty, in his case, the lookout circular were issued. He was given the Pravasi Bharatiya Samman later on. He was brought to India. I mean, that is the absurdity which we are facing with. Anyway, this is a very welcome move. This is the way forward. Let's see how it goes.
Welcome judgment and lots of hope from our Supreme Court. Closing comment of the show by Advocate Weber.
Tarun, as I said earlier, positive. I would be surprised if it's interfered with. It is something that actually the government may look at positively as well. Let's not presume necessarily that the government is going to take this as a setback, because if it infuses investor sentiment and produces the right results, then that's something that any government would want. Also, very important, the distinction that it is only for cases where it had a national impact, right? It was not for every loan default, but what accounted for national impact, etc., was never defined. That arbitrariness has also been taken away. I mean, it was almost as if the big boys are going to be under the scanner and the small businesses don't get impacted. But just because you're a big boy in a big business does not make you a criminal, right? That sentiment needs to be upheld. The government also, by the way, did one positive thing amongst other things, during the COVID period, they brought about 10A in the IBC code, which said any defaults during that period cannot be invoked, right? So this is actually, adding to that sentiment. It is a positive thing. Let's see where it goes. As I said, it's election season.
Thank you. This has been a very important show that we did today, especially in relation to industry. We all know how much businessmen have been troubled in the past few years after the LOCs were invoked rampantly by banks, businessmen landing up at airports and, finding out that, they can't travel abroad without any intimation by the banks. This was done. They had no idea that this had been invoked. So we have to thank Justice D.S. Patel, Justice Madhav Jandar, and as Karthik pointed out, it was his last day. So he spread positivity and a lot of encouragement for businessmen in India by this judgment, something that would boost investment in India, because these things are discussed abroad. When, when an Indian businessman says, I've been prevented from flying out, they wonder why. I mean, these things do impact also investment. So it was no small measure. The courts have stuck their neck out and struck this down. We'd like to thank them, and let's hope for something good that happens in the Supreme Court. We'll follow that and of course do shows on that, but appreciate that Advocate Weber and yes, sir.
I'll just end by saying that there will be a likelihood that Justice Gautam Patel would be in Supreme Court practicing while this appeal is filed.
Okay, that's an interesting note to end this show. Thank you, Karthik Seth, for joining us. Pleasure. Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.